So good morning, everyone. For those who don't know me, my name is François Tanguay-Renaud. I'm a prof here at Osgoode Hall Law School. I'm also the director of the Jack and May Nathanson Center on Transnational Human Rights, Crime and Security, which is very pleased this morning to be hosting what I would say is, and hope, is the first of many morning conversations. A lot of people pass by Toronto and carry a lot of interesting stories with them and a lot of messages that we want to hear here at the center. And we thought that having these morning discussions might be a good way of generating enthusiasm for these conversations. We're very pleased today to be partnering for this first conversation with the new Israel Fund of Canada, which initially contacted us and said, do you want to put something together with us? And we said, definitely, and we thought that an appropriate theme, given our visitor today from Israel, would be minorities and the state in Canada and Israel, a conversation, right? Trying to draw parallels and contrasts between what is happening within our two countries. But before I say more about the theme and introduce our co-panelists this morning, I would invite Orit Sarfati of the new Israel Fund of Canada to tell us a bit more about her organization and welcome us. Yes.
Great. Well, thank you, François, and thank you, Liel, for making this possible. Thanks also to our speakers for coming here this morning. I want to say something very brief and then hand the mic over to Professor Ziemens for perhaps a little bit more perspective. New Israel Fund of Canada has been around for nearly 30 years. Its work is focused in Israel. The organization partners with Israeli NGOs on projects focused on domestic social issues, particularly women's rights, economic justice, civil and human rights, and religious pluralism and tolerance. We look at the spectrum of what the needs are twice a year in Israel. We speak directly with activists across the country to then determine where can the impact be in capacity building, in forming grassroots trends and organizations, and then in the cases of the Association for Civil Rights in Israel and other organizations, we take up long-term partnerships because we measure our goals both short-term, immediately, and then long-term. So that is what New Israel Fund of Canada does. We're nationwide, and it's so nationwide that we're taking a flight to Montreal in about an hour, so very, very nationwide. Before we start this conversation, I want to invite Fred Ziemens to talk more about New Israel Fund of Canada. He is both a faculty member here at Osgoode and also a committed supporter to New Israel Fund of Canada. Fred.
Thank you. I'm sorry I'm a few minutes late. I thought we were meeting on the second floor. But it's wonderful to have this discussion here at Osgoode because Osgoode itself has been very much involved over the last decades in social justice programs, and the involvement of many graduates of Osgoode and of members of the legal profession in Canada have been very involved in issues of civil liberties. And naturally, many of us who have been concerned about democracy issues in the State of Israel and working towards social justice and equality rights within the State of Israel have become involved with the New Israel Fund. And we're fortunate today to have with us one of the leading persons involved in social justice in the State of Israel, and a person who has been deeply involved in his young life in the involvement with social justice issues in the State of Israel, initially through his work with respect to the needs and rights of persons of gay, bisexual background. Started an outstanding program in Israel, and has in the last number of years become involved in the civil liberties aspects of Israel. And I really don't want to take up much time from him, because I've already had the pleasure of hearing him yesterday, and I know that all of us here will really enjoy hearing from him.
Okay, thank you very much, Professor Zeman. So to introduce our speaker, we have the one and only Hagai El-Had, who's visiting Canada right now, and we're fortunate to have with us, as Professor Zeman just mentioned, this morning at Osgoode Hall. And he is one of the foremost human rights activists in Israel today. And he's also the executive director of the Association for Civil Rights in Israel, acronym ACRI. And ACRI is Israel's oldest and most established human rights organization. It was instrumental in, for example, banning the use of Palestinian civilians as human shields, was instrumental in the registration of marriages of same-sex couples in Israel, as well as the affirmation of women's participation in Air Force pilot tests, as well as many other landmark changes in the Israeli state. In conversation with Mr. El-Had this morning, we have Craig Scott, who is well known here at Osgoode as a professor on leave and former director of the Nathanson Center. He is currently Member of Parliament for Toronto-Danforth, the seat that was previously held by Jack Layton, and he's the official opposition critic of, for democratic and parliamentary reform, and he sits on the Procedures and House Affairs Committee of the House of Commons here in Ottawa. And finally, we have with us Cara Zwibel, who's the director of the Fundamental Freedoms Program, the Canadian Civil Liberties Association, which provides legal opinions, research, coordinates interventions before the courts, and prepares submissions to legislative bodies on matters of fundamental rights. So as I mentioned to you earlier, the theme on which we agreed this morning is minorities and the state in Israel and Canada, a conversation. I don't want to say much more because I want to leave it to our speakers to develop this theme. But what I thought I would do, and in fact agreed previously with our speakers, is that we would put initially two main themes on the table, which are derived from events, issues that are very much in the limelight here in Canada right now. The first one is the so-called Charter of Quebec Values, which has brought to the fore a debate about what the meaning of secularism, the meaning of multiculturalism here in Canada, the way we live together and the way the state ought to behave vis-a-vis the larger population and what that means. And the other issue is the protest movement born in December 2012 from a long lineage of other movements. That is the Idle No More movement, which is an indigenous people-led movement, which was created, as it were, in reaction to various bills brought forward by the current Conservative government of Canada, rescinding, in a way, or threatening to change, alter long-established treaty rights, as well as acquired statutory rights of Indigenous people here in Canada. So we think that these issues always warrant more discussion, and we also think that there are issues in Israel that deserve, from which we can learn, both in terms of parallels and contrasts. One of these issues is the possible introduction of a basic law in Israel, which would declare the state of Israel to be a Jewish state. So again, the issue of secularism or the place of religion within the public sphere being thrown into the limelight. And the other issue is that of perhaps less emphasized issue in international media of the rights of Bedouins in the south of Israel. And we think there's a lot of cross-pollination and good discussion to be had about these issues. So without further ado, I would invite Mr. Al-Aad to kick off the discussion by talking to us about what he thinks about these two issues of importance.
Great. Thank you very much. Thank you for the warm introduction, and thank you all for braving the ungodly hour of 9 a.m. and actually making it here this morning. Most of you actually do seem awake. I'm very encouraged by that, and I'm hoping that you will remain awake even 10 minutes and 20 minutes and half an hour from now. But that's partially also our responsibility, so we'll certainly do our best to keep it interesting. Also, obviously, I know very little about the two issues of reference from the local context, so I'm very eager to hear more about them from my colleagues here. So in the meantime, I will elaborate on the two issues that we decided upon from the Israeli context, imagining, fantasizing, desiring that they somehow relate to what's coming. But I will discover that together with you in 10 or 12 minutes or so. Okay, so on the two issues that I wanted to provide some more context and content. So one is, as we said, one is very real, and that is the ongoing plight of Bedouin communities in the south of Israel in unrecognized villages, an issue that has been with those communities basically in various incarnations since 1948, since the state is established, and there is now the potential of major changes for the worse from our perspective in that regard, with the passage, the initial passage with first reading of a new law that aims to finally resolve the dispute between the Bedouins and the state. So this is real and ongoing. And the other is theoretical, looking forward with the potential passage of another basic law. So let me start with the latter and then go back to the Bedouin communities. So first, just a brief constitutional introduction to the Israeli mess in that context. You may be aware of this. If you do, then I apologize. As you know, Israel doesn't have a constitution, and instead of that, the compromise that was agreed upon a short time after the state was established was that Parliament will pass a set of basic laws. Once that project will be done, those basic laws together will become the state's constitution. That was supposed to be done within a period of 2 years or so. Since then, more than 6 decades have passed, and that project isn't finished yet. However, over the course of the years, a growing number of basic laws did pass, covering some issues, but not all of the issues that one would imagine would be included in a proper, functioning, modern constitution. And the last, perhaps major fork in the road in that process was some 20 years ago with the passage of the so far last two major basic laws, one of them being Basic Law, Human Dignity and Freedom, which has been very instrumental in the defense and advancement of human rights and civil liberties in Israel. After that basic law was passed, the High Court decided that a critical mass of these laws have been reached, and since then the court has assumed also the authority to provide judicial oversight of legislation, and in a number of cases, including also in a very well-publicized case of just a week ago, the court has stricken down, I think by now, maybe some 15 or so laws over that period of 20 years. The last one just a week ago, the trashing of the anti-infiltration law, a law that has sent asylum seekers in Israel to administrative detention of periods of no less than 3 years. That law was passed about a year and a half ago, and this is no longer the law in Israel. So that's the process of accumulation of basic laws on the way to a constitution. Nowadays, over the past year or so, parliamentarians have been floating the idea of passing another basic law, one that perhaps wasn't imagined in 1948, that would define Israel in a basic law as the nation state of the Jewish people, or as a Jewish state, all depending obviously on the exact language that would be used in that law. And we've seen some drafts pass around in the previous Knesset, and they were set aside. And most recently, the Minister of Justice, Tzipi Livni, has delegated the framing of a new draft of that basic law to no other than Professor Ruti Gabizon, who is a famous law scholar in Israel and a past president of ACRI, which, how shall I put this in diplomatic terms? I believe that over the course of the years, her positions have changed somewhat than where she was on these issues when she was the president of ACRI. So we'll see what kind of draft is suggested in that context. But what is it that we're expecting? And in that context, it's very helpful to read some of the writings of the think tanks on the right in Israel that are the backers and the precursors of many of these pieces of legislation. And we've seen in other initiatives really a close relationship between position papers formed by bodies such as the Institute for Zionist Strategy, and then a year later down the road, a bill is introduced in the Knesset which looks very similar to what was suggested in that think tank's work. And lo and behold, some months ago, they published a position paper with regard to the legal need to pass that basic law. So it's very interesting for anyone that has got used to the endless legal and public debate in Israel about Jewish and democratic Israel, a phrase that has become front and center since the passage of that basic law of 20 years ago of human dignity and freedom, as if in Israel there exists a horizontal balance between the two. The Jewish nature of the state, whatever we mean when we say that, and the democratic nature of the state as we understand it. And if you read the document written by the Institute of Zionist Strategy, then their point is based on a completely different worldview of the situation in Israel. They're claiming that there is no horizontal balance, and that actually after that basic law was passed 20 years ago, that democratic values have somehow overtaken the country at the expense of Jewish values. And I think that anyone that's been following the analysis of the levels of discrimination that continue to exist in Israel would be quite taken aback by the, I would frame it as this imaginary view of where things are. From where we're sitting, we never even reached a horizontal balance. The situation has never become even close to that. And if they would pass such a basic law, then we would be at a more extreme vertical imbalance where Jewish identity takes precedence over democratic values in Israel. But obviously they see things very different. But if you go into the small print of that position paper, then you can read also specifically what are the tangible, pragmatic goals that they see with the passage of such legislation. It's not just declarative legislation. And they're talking about bills and laws that would govern issues such as access to land, participation in the political process, the status of the Arabic language in the State of Israel, and other issues that run to the core of basic principles of equality in any society, and specifically in Israel. And again, if you read about the way they describe the situation from before 20 years ago, then it's like romanticizing about that period in which the state could get away with blatant discrimination, as if during the past 20 years that has become completely impossible. And somehow with that basic law, they would be able to fix things and put the country back where it was during that period. And again, obviously, factually speaking, when we analyze the systematic, ongoing, policy-driven discrimination against Arab Israelis, then this is a situation that existed before the Basic Law was passed 20 years ago and still remains. We're just very concerned that if such a Basic Law would now be passed, it would send us back maybe 20 years of recent achievements that we've accumulated in the struggle for more equality in Israel. So stay tuned to see how that process continues, with the next step of it likely being the publication of a draft by Professor Gabizon, who is already on record on various issues that relate to that legislation. Professor Gabizon wrote an op-ed some years ago where she backs the legal possibility of having villages for Jews only in Israel. So in the context of access to land, we can expect her draft to back that kind of discriminatory policies. There's also position papers of her work with regard to immigration rights to Israel, and so on and so forth. So in some ways, this is not a complete unknown what is to be expected from the draft, but let's wait and see what exactly is going to be written. On the Negev, on the unrecognized villages, so just a bit of background. We're talking about several dozen communities in the south of Israel, in villages that either pre-existed the establishment of the state, or villages where people have been moved by the state after it was established from one place in the Negev to a different place in the Negev. And ever since that period, the state doesn't recognize those villages. What does it mean that it doesn't recognize these villages? From the Bedouins' perspective, these are their ancestral lands. They have a land ownership system that has been serving those communities for generations. It has been recognized by the Ottoman Turks at the time. After that, it was recognized by the British Mandate. It was actually also recognized by some of the first Zionists that wanted to live in the Negev, because they paid good money to buy land from the Bedouins. So apparently they accepted the fact that the land belongs to the Bedouins and that there is an ownership system in effect. But the state of Israel does not recognize the system of land ownership, nor the fact that these villages are there in a legal and acceptable way, which means that the state for many years denied its responsibility to provide basic infrastructure, health, electricity, roads, and so on to these communities, which resulted with the Bedouin communities being one of the most impoverished, poorest communities, with appalling statistics on all social and economic measures that you could imagine as a result of this process. Over the years, the community and other organizations, and us as well, have been involved with the struggle to have the villages recognized. And for many years, the strategy was to win a gradual recognition in the sense of trying to pitch the following argument. Let's set aside, in the meantime, the question of land ownership. However, whether the state accepts the fact or not, the state has a responsibility of providing basic rights, basic infrastructure to the people that live there. So forget about land ownership, but build the health clinic, and have a school, and have a safe road for the kids to go to the school, and have electricity so that the health clinic can cool the medications that have to be there, and so on and so forth. With the hope that after winning the school and the health clinic and the road, then eventually the state will relent and will also recognize the village. And that has happened in a number of cases. However, till this day, about a third of the community still lives in villages that are not recognized. I want to be brief so not take too much of the time. The last stage of this ongoing dispute between the state and its citizens, tens of thousands of Israeli citizens who are Bedouin who live in this appalling condition, was the passage of with a small margin in first reading of a potential law based on a plan developed by former Minister Benny Begin. So, and before that, and after a planner in the Prime Minister's office called Udi Praver. So if you read about it in the news or Google it, then it's often related to as the Begin-Praver plan. And the plan there is to finally resolve this ongoing dispute, but are they doing it in a way that respects the ancestral rights of Bedouin communities? Are they doing it in a way that recognizes the land ownership of the Bedouins and so on and so forth? None of the above. It is a system that first carves out of the Negev a certain area in which only their potential future Bedouin villages could exist, which doesn't correlate to the current geography of where the communities exist in the Negev. So it means that some people will have to be displaced so that they eventually live in that region of the Negev that has been carved. And there's a system of potential compensation for land ownership, but it is done in a way that revokes the constitutional rights in the context of land ownership from the individuals. And it does that in a variety of ways. If there are several owners of a piece of land and you don't manage to get all of them involved in the process, then you lose, right? So foregoing your individual ownership rights. If you buy into the process early on, then the compensation will be bigger. But if you wait a year or 2 or 3, then you gradually lose more of the potential compensation, and eventually you may lose everything, and so on and so forth. So these are procedures that don't exist in any other similar circumstances of land disputes anywhere else in Israel. And also the potential legal recourse that one would have in trying to appeal against the administrative decisions that would be made as a result of the implementation of this law, if it is passed, then that would also be highly reduced compared to what would be available for any other citizen in a situation of a land dispute with the state. So obviously, the community is very much against that. We are very much against that. We are encouraged by the fact that the bill did pass in the first reading only with a small margin. So that does give us some hope. It is now going to go to committee, where it will be prepared for the second and third reading. And we'll see whether it will eventually become law, and if it does become law, in exactly what form and shape. And eventually after that, whether it will be challenged in the High Court, and if the High Court will intervene or not. And with that, I will pause.
Well, thank you, Hagai, for this, what I think is a very informative survey. I certainly learned a lot, and despite the different histories of the two countries, I already myself, being a bit foreign to these issues, still begin to see some interesting sort of sides of comparisons, right? So you mentioned that the possibility of entrenching the Jewishness of Israel as part of its basic law is something to be feared on grounds of inequality. Yet in Canada, what seems to be happening with the Charter of Quebec Values is that we're elevating a certain idea of secularism in the name of equality, right? That namely the equality of gender seems to be the side of equality that is at the forefront of most people's mind when they say this. But at the same time, that bill has been decried from all corners of society as being an incredibly discriminatory law, first and foremost on grounds of religion. And so the question is, how do we achieve that balance? So that for me is something that's interesting. And on the question of Bedouins, obviously, the very similar issues to those that arise here. On one side, the question of ancestral claims, ancestral rights. On the other side, a history of neglect by the state of separate systems to try to resolve conflicts, and at the same time, perhaps a failure of proper recognition of the claims and rights that are being asserted on the part of the Bedouin communities. So on these issues, I wonder whether I could ask Craig Scott perhaps to to share some thoughts, some reactions to what has been said for 10 minutes, and then we're going to pass it on to Cara.
Thanks, François. Yeah, there's an awful lot of food for thought in what Hagai just outlined. And I'm a bit caught between whether to respond with some of my relative circumscribed knowledge of the Israeli context, or maybe set out something in parallel or in contrast. And I think I'll do the latter. I'll just set out a few points that have some very rough parallels. The whole issue of the Quebec Charter and how that has interesting parallels to the debates around a Jewish and democratic state in Israel. Probably goes a lot further too, because one has to look within the bracket of what Jewish means, including the relationship between secular Israeli Jews and ultra-Orthodox and other communities in Israel to, I think, fully appreciate what some of the parallels to the Quebec Charter issue might be that I'm going to just briefly talk about. And the other thing is whether or not focusing on the Bedouin and then creating a parallel with Aboriginal peoples, First Nations in particular in Canada, is a direct parallel or not is probably is an area I probably shouldn't tread, because there's just so many dissimilarities. But I will speak very briefly about the whole context of Canada so many years on since our official formation, still being in a situation of extreme exclusion and alienation of a segment of the Canadian population, the Aboriginal people. I think to frame the brief comments I'm now making, one has to think in terms of how difference is constantly entering the picture as both a value and a threat. It's some of the classic dilemmas of around difference and how different understandings of equality then layer themselves onto that. So in Canada, we often have ships passing in the night when it comes to people talking about respecting equality or respecting difference, or not wanting difference because it's not a matter, it's not respecting equality. People often mean different things when they're engaged in the same conversation. And so with the Quebec Charter, let me go there first. What's so interesting about that, what's going on in Quebec, is that a set of values related to how difference amongst individuals, in particular religious difference, should be treated by the state, particularly in relation to the face of the state, if you like. The whole question of difference amongst individuals is also bound up in narratives and even arguments around collective difference. So the whole idea of Quebec, Québécois identity and Quebec history is very much part of the framing of the debate and the understanding of some of the justifications being offered by the government of Quebec for the Charter that taps into some deep-seated feelings amongst large chunks of the population in Quebec. And so some of this is being deliberately framed by the Parti Québécois government and some other supporters as either as a political issue in the sense of trying to create us-them dynamics out of this, where the whole issue is somehow or other what's being presented in the name of the Quebec Charter is somehow an articulation of collective identity and thus collective difference from the rest of Canada, or collective difference in and of itself. This is who we are, and therefore others who have different ideas about the place of religion in society have to accommodate to our view of what neutrality of the state and religious rights versus secularism entail. So I think it's very important to keep in mind that, as is classically the case in so many of these kinds of debates, it's not a freestanding debate about where everybody's talking about conflicts or balance amongst individual rights. It's also a question of how collective identity and collective difference plays into it. And so I think, as you all know, the proposed charter, now we have effectively a white paper on it, would enshrine certain ideas about the state being such a secular institution that basically, supposedly, all indices of religiosity have to be expunged from the state's face. The humans who represent the state, just as the state can't treat people better, worse, or just frankly differently on the basis of their religion, the state somehow or rather becomes personified as an actor interacting with individual citizens and society at large, and it somehow or other has to be this completely not just neutral, but almost neutered entity, such that the charter is going to specify, if the government got its way, that people working for the state, a clerk in a teller's office, somebody in the back office, anybody working for the state, must not wear, sport, as they might put it, conspicuous religious symbols. And the diagrams that have been produced so far as examples tend to be of the physical sort of an overly conspicuous cross. It's not a matter of being visible or not visible, it's conspicuousness is the test. And so who's going to be judging what's conspicuous and what is another issue. By definition, it appears anything that's a headdress, a head covering that is religious in purpose is by definition, it would appear conspicuous from the diagram. So everything from a kippa to a turban to a headscarf. Doesn't help that in Quebec, in French, the word voile is used interchangeably between the headscarf and the face veil. And people are completely confused in large parts of Quebec about whether or not, whenever the word voile gets used, they have this image, when at the same time, it's also just a headscarf it's going to be banned. One could see the whole issue of a face veil being quite different when it comes to interacting with the public. And the NDP's perspective on this, and this is my own as well, very forcefully articulated by our leader, Tom Mulcair, is that this is unacceptable in any kind of a robust human rights framework. And that there's enough normative reference points that are also part of Quebec values and culture for Quebecers themselves to work out why this is such a problem. And that's why it's such a good sign that whole segments of the nationalist and even independentist parts of Quebec are also not in favor of this. You go to one of the towns that was at the heart of the whole question of people who come to Quebec should completely adopt to Quebec practices and ways of life. Apparently that the village in question is completely split right down the middle between whether this is a good or a bad idea. And people are having very serious concerns, and a lot of the folks in that village who are against it are themselves probably pro-separatism, pro-independence, etc. So it's very important that the debate is crossing that line, because the Parti Québécois very much wants to make this some kind of a wedge issue for creating dynamics of the rest of Canada is so different from us and/or are behaving with such disrespect to us by the way they're criticizing what's going on in Quebec, that why don't we actually revisit the whole question of Quebec's status kind of thing. That's the end game beyond Pauline Marois wanting to get some more percentage points in the next election, I think. So the way we've thought about it is that it's very important that everybody realize that this is a question of personal identity and expression, individual identity, personal identity, and expression. it's not a question of imposing religion on anyone. And so I think it's really important that the fact that somebody is serving you wearing a turban or a kippah is not some kind of statement in the name of the state that you must somehow or other adjust or accommodate to the fact that I have these religious beliefs. It's irrelevant to the social interaction that's part of the service interaction between the state official and the person. And so instead, the question of imposing religion actually is working the other way, that the goal of a neutral state is fine, but the choice of means cannot themselves actually end up being discriminatory or exclusionary. In the case, what's going on with the Quebec Charter is that the effect, I won't say anything about the intent, but the effect is far from neutral. It's absolutely the opposite. It's actually singling out religious identity as some kind of a forbidden feature of identity. I could be hired by the Quebec state and serve people as much as I want it, wearing to maybe symbolize my identity, shirt collar that's full of rainbow flags and all kinds of things that suggest this is who I am. Not my style, by the way, but I could, right? Nothing in this that would suggest that that's an illicit form of projecting my identity. Yet you can imagine as many people sort of taking umbrance or saying that's not necessarily an appropriate garb for a member of the state as something that's more religious in nature. And so ultimately what that tells you is that what's really going on is the Quebec Charter is trying to protect people from offense. Somehow or other people are offended by the fact of religiosity. So it's not simply the whole question of whether or not different religions are to be treated better or not. There is a serious current, and this is part of the collective narrative we have to take into account. Part of collective identity in Quebec does dig deep into the history of a state that was basically intertwined with an interfering and authoritarian Catholic Church. And the whole source of the crucifix that still hangs in the National Assembly, it's not a symbol, frankly, of the Catholic Church. It's a symbol of collusion between the Church and the Duplessis and every other era before it. And so as a historical artifact, if there's a big plaque on it saying this is a symbol of exactly what should not happen in a state, then I'd be very happy with it staying up there. At the moment, however, it's staying up there as this kind of weird historical heritage symbol that is somehow deemed to be compatible with the idea that the state is going to be neutral in all these other really minute ways where individuals who work for the state somehow or other have to bear the burden of presenting a neutral face. So the whole idea that people are taking offense at religiosity is at the core of this. And we do have to understand that it does come from somewhere in Quebec. That there may well be some for whom it's a veiled question of our secularism also comes with a Christian heritage, that kind of secularism. But for others, it is a very deeply held value, but that is not just coming out of the pure space of the cerebellum, but it is coming out of Quebec history, where people remember and resent the control the Christian church, the Catholic Church in particular, had in Quebec. And I think people outside of Quebec have to really recognize that as part of the narrative. People cannot assume that this is simply about not accepting difference in the contemporary multicultural way. There is that strand, but part of it is coming out of Quebec's collective narrative of how they threw off the shackles, if you like, of the Catholic Church's interpenetration with the state. And if people don't recognize that, there's going to be a lot of talking past one another as this debate continues.
Thank you very much, Craig. Craig didn't have time to address the I Don't Know More movement, and that's totally fine. The way we designed this little morning chat is basically we told people you react to whatever you want. And it seems that that aspect of Hagai's talk, obviously, brings up issues for discussion that are very much at the forefront of people's mind today, so I'm not surprised at Craig's reaction. Cara.
So maybe I'll just talk a little bit about I Don't Know More to start, and then move to the Quebec Charter of Values. I think it's true that we shouldn't overstate the parallels between the situation of First Nations communities in Canada and the situation that Hagai described in the Negev. But there is, I think, a parallel in terms of a real failure on the part of the state to address a persistent, serious human rights crisis. And I think what's really interesting about the I Don't Know More movement is that some of the reactions from people across Canada, some were quite supportive of the movement, but many actually felt, ironically, that First Nations people were getting special treatment during the I Don't Know More protests, that if any other group had blockaded railroads or blocked roads, the police reaction would have been different. And we certainly heard from individuals, we at the Canadian Civil Liberties Association certainly heard from individuals talking about, why aren't the police reacting the way they would to other protests? Why do First Nations people get special treatment? Which we were disturbed by, but it was an interesting sort of confrontation of the, I think, lack of understanding and really just the ongoing failure to address this very significant deficit in our democratic system. The position in law has often been that the relationship between First Nations communities and the Canadian government is sui generis, is special, that there are special rights that attach, but I don't think there's been a really good reckoning of what that truly means, and I think some of the reaction to the I Don't Know More movement maybe highlighted, how far we still have to go. On the Quebec Charter of Values, which is definitely an issue that's more at the forefront of my mind in my role at the CCLA, I agree with much of what Craig said. I think I need to sort of point out that the idea of removing all indices of religiosity from, the public face of the state is actually not what the proposal even purports to do. We talked about the crucifix hanging in the National Assembly. There's no discussion of the fact that in, municipalities and places across the province, council meetings are sometimes started with a religious prayer. That apparently doesn't affect the state neutrality or the appearance of neutrality of the state. But if your physician happens to be wearing a turban, that apparently does. There's also an exception actually for elected officials. So those who are elected to office can display whatever symbols of religiosity they'd like. And presumably those are actually the people that you would think are the most obvious face of the state. I know Craig talked about the potential effects of the law and was careful not to suggest intent. I am going to suggest a bit of intent on the part of the government of Quebec. I have to say that I think there have been symbols of religiosity displayed by members serving the public on behalf of the state for a long time in Quebec, but it's only somewhat recently that there have been particular controversies around the wearing of a niqab or a hijab, and I have to say that unfortunately I think that's where a lot of this comes from. If you look at the the Quebec government's site, the website about the Charter of Values, it talks about there being, recent situations that have made people uncomfortable. And I think, it's not just that some people find it offensive, it's actually that it's less than offensive, it's uncomfortable. Some people are uncomfortable with, the way in which different people choose to identify their religious beliefs or backgrounds, or quite frankly, their cultural backgrounds. And that just isn't a good reason. It's just not a good enough reason to violate rights that are protected in our Constitution. The Canadian Charter, the existing Quebec Charter of Human Rights and Freedoms talks about, the fact that rights are not absolute. The right to freedom of expression isn't absolute. The freedom of religion is not absolute. But if you're going to limit these freedoms, you need to do so in a way that's reasonable, and you need to do so in a way that has some rational connection to the goal that you're trying to achieve. And I can't see how requiring a physician or a school teacher to remove any any conspicuous symbols of religiosity achieves this goal of state neutrality. I think it also, maybe the interesting link to, the question of what does a Jewish state mean? What does a religiously neutral state mean? Is that we can somehow stop in time what those terms mean. Presumably, the idea of what it would mean in Israel, for Israel to be a Jewish state, has evolved and is evolving and will continue to evolve. And the example of keeping the crucifix up in the National Assembly based on Quebec's heritage suggests that there's no more heritage to come. That individuals and the identities and backgrounds and experiences that they bring when they come to the province, when they're second and third generations with backgrounds from different places, that they have nothing to contribute to the ongoing heritage of Quebec society. And so, I think that it probably is obvious that I'm quite concerned about the Quebec Charter of Values. I am hopeful that it actually won't come to fruition, although I am a bit worried that perhaps the idea was to introduce something so extreme that it surely couldn't succeed, so that less extreme but still certainly offensive measures that are unconstitutional and violate individual rights and freedoms, might be passed and seen as a compromise position. So maybe I'll leave it there, just as my sort of comments on those two issues.
Okay, well, thank you very much, Cara. I just asked Hagai whether he wanted to react, and we just conferred here and thought that in the interest of time, it might be a better idea to simply ask the floor whether you have any questions, comments, so I already see one hand, Professor Faisal Baba. What I would ask anybody who has questions, because this is recorded, is that you stand up and go to one of the two microphones on the sides to ask your question. Thank you. No, so that the decision was that we would simply engage in a conversation.
Okay. Thank you for all of these comments. My question is to Hagai. Thanks for coming so far to visit us here. I'm trying to understand your concern about the proposed basic law, or I'm not sure if it's been proposed yet, or the discussed basic law. There is a broad consensus in Israel that does define the state as Jewish. The laws have been informed by that perspective. I think it would be controversial for any politician to stand up and challenge that idea. So what is the concern with constitutionalizing that, especially considering that the state operates effectively as though that is a de facto constitutional principle, or at least it seems to underlie most lawmaking? Is it a concern about it emboldening the right to promote a more religious Jewish identity? Or is it a concern about making it more difficult to move towards a more equality-based concept of citizenship that recognizes the indigenous Palestinian national minority as a national minority, as a constituency with some sort of constitutional status? Presumably, the constitutionalization of Israel as a Jewish state would put an end to any possible claim by the Palestinian minority for a status similar to the way our constitution in this country is established, as creating essentially two national communities, of course, to the exclusion of the indigenous community. So I would actually draw the parallels to our British North America Act, which essentially ousted our indigenous population in creating a myth of a binational state in the same way that Israel created the myth of a uninational state. But I'll leave those comments and the question with you.
Thank you for the question. I guess maybe a different way of putting it is that apparently there is a growing number of politicians that are disappointed with how inefficient discrimination has become. And maybe they attach that to the achievements of some 30 years or so of fighting against policy-driven systematic discrimination. And they want to find legal ways of undoing that. And perhaps part of the political circus that needs to be played out in order to provide legal and moral justification for that is really portraying how horrendous things have become. I hope that the cynical tone is clear enough in a situation where it is more difficult, more complex, and it has become more difficult, more complex to excuse, for instance, why is it legal, just, moral, Jewish, constitutional, to have, for instance, laws that would back villages that could end up having only Jewish residents in them. So the passion behind such legislation is to go back to the good old days where you could get away with that in a more easier, more effective way than what they claim has become the situation. To what extent have those that have been fighting indeed for equality in Israel, ACRI amongst them, has succeeded in entangling discrimination and making it less acceptable, less publicly digestible? We can have a lengthy conversation about that. I would say that we are not satisfied with what we've achieved. I think we've gone a long way. I think there's still a very long way to go. And the concern is that this may set us back quite a distance. I also agree, if that indeed was the linkage that you were making, in the sense, in the context of how this is interacting with the peace process. As we all know, peace is just behind the corner, and in 7 months there is going to be a final status agreement between Palestinians and Israelis. As we all know, this has been the situation for the past 20 years. But in the meantime, someone is already being submitted with the bill for that is just behind the corner. What is that? And in that context, I think it's interesting that it goes back to the same individual, Tzipi Livni, who is the justice minister, and in that context, she would be responsible for such legislation in the context of that basic law, and she's also the chief negotiator by the government of Israel in the peace conversations with the representatives of the Palestinian Authority. And in that sense, part of what there is a desire to defend, to establish, to further solidify and I'm not theorizing here, these are statements made by Tzipi Livni herself and others key leaders in Israel, is to really solidify Israel as a Jewish state, and that's why there are demands from the Palestinians to recognize that and so on. But with the passage of such a law, I think it's difficult not to think about it also in that context, that regardless of what Palestinians will or will not do, already, before that corner is turned, whether that's going to happen in a week or in 50 years or never, that law will already be passed, and it will be done, right? So it's another contribution in the same direction, so that whatever national aspirations Palestinians could have in Israel, as the largest national minority in Israel, then that it will become very clear, legally speaking, in the way that is most solid in Israeli law, through a basic law, that will not be a possibility.
Any other questions? Well, maybe I have one. So Craig mentioned or brought to the floor the idea of history and its influence on how states shape themselves. And the question is as follows, probably more directed at Craig and Cara, but a guy might chime in. How can a state in today's day and age aspire to be fully neutral in light of its history? Right? In the case of Israel, we're not going there at all, but even in the case of, say, the French state, which has a very militant notion of what it means to be French, and that is not to be religious. It's still founded on a certain idea, of a certain set of values that are intimately connected to the values of Christianity. So in the case of Quebec, as Craig and Cara have mentioned, we have a half-hearted effort, in a sense, to get, or to go and to move into that direction. But at the same time, there's this deep sort of sense that things like the crucifix, things like funding for private religious school, right, confessional school, which is still rampant in Quebec. I mean, I attended one of those. In fact, in the 90s, I was a student delegate at what was called the États généraux sur l'éducation, the General Commission that the PQ at the time, government was Parizeau-Bouchard time, but I put together to study how the education system in Quebec at the high school level should be arranged. And the commission came out with a recommendation, which is, well, scrap all these private schools, which are highly subsidized by the state. In fact, the best schools in Quebec are private schools, which you only pay $1,000 to attend a year because the state pays the difference. And Pauline Marois was the Minister of Education at the time, and she wanted to endorse that proposal. But Premier Bouchard at the time stood up and says, well, we can't do this, right? This is not Quebec. This is not part of our history. And that debate was already very present in the core of PQ kind of internal deliberation. So how far can we hope to achieve neutrality? Is this a pipe dream? Is this just an ideal that is out there? Is that something reachable? And in fact, what should we hope to achieve? What should we hope to reach?
I think at one level you have to start with the recognition of where history has left you, and then ask whether or not where principle and a degree of sort of accommodation to sort of practical realities, where the dividing line is there. Not exactly sure in any abstract sense whether or not the whole question of the embeddedness of the historical identity and how that makes a myth from the beginning of any pretenses to subsequent contemporary neutrality, when history itself just sort of frames and shapes everything. I think that's probably the basic point. I was wondering if I could, this is not much of a segue, but a bit of a tangent. where history matters in a way that I've always been fascinated by in Israel with respect to the question of the different social economic status in particular of Arab Israeli citizens, which is the whole question of where the military fits in Israel. Serving in the military is a huge part of Jewish Israeli identity, and it's actually for men and well, for women too, I guess, mandatory with certain ways you can do alternative service. And what's so fascinating about the question of how the military fits into the ongoing marginalization of Arab Israelis is that at one level, the Israeli state is being very understanding in the sense that there's this accommodation to history where Arab Israelis are not subject to mandatory service in the military. And it's not, and it tends to sort of dovetail with the fact that there's not an awful lot of Arab Israelis, up until at least recent times that I know of, that really want to serve in the military. And so there seems to be this kind of either an accommodation or a sort of a principal acceptance of a historical difference. There'd be good reasons why Arab Israelis might not want to serve in the military. At the same time, what we know that happens is that the military is serving in the military is the sort of the cauldron of how people form relationships, learn certain skill sets, have all kinds of opportunities open up in society after post-military. Whether or not some of them are formal, you have to have been in the military to be involved in certain technology and other industrial sectors, for example. But the fact is there's pretty good evidence to say that not having served in the military is a huge disadvantage for Arab Israeli citizens in Israel. And it itself helps continue a degree of marginalization at the socioeconomic level. And so at the level of how history and collective identity and marginalization interact, the whole question of service in the military, I think, is an absolutely fascinating aspect of how difference is both recognized and at some kind of a accepting level, but then that acceptance helps perpetuate a difference that's a more negative form of difference. I'm just wondering if this is one of these unresolvable situations, because it's hardly going to be solved by making military service mandatory, and it could be solved by a bunch of laws saying that serving in the military should in no way be an advantage to your future chances in life, but that won't go anywhere in the way the real world works. So I was wondering, Hagai, if you had any comments on that.
I mean, we can reflect on this issue, and it obviously is very interesting. While people reflect, politicians pass laws. So the context, the de facto context in which this is often played out in Israel is that, and here perhaps we go back to how advancing discriminatory policies has become somewhat complex, and we want to make it easier. But for instance, the term benefits for those that have served is one of the key vehicles that looks acceptable in the domestic ongoing conversation in Israel for discrimination, because you're not saying that, oh, we're just going to give it to the Jews and not give it to the Arabs. We're just giving it to those that really put themselves, in the way you're also setting aside other communities that don't serve, the ultra-Orthodox community in Israel, some people with disabilities, and so on. So it's somewhat complex, and you don't get the clean result exactly of what you would have wished, but it's close enough, and it doesn't look too bad, right? And again, this is not a theoretical theme, but rather something that is being fought extensively all of the time, with a major push on this issue by the current government, and that wants to advance more benefits for those that serve in a variety of ways. And it's interesting to notice how, at least on one specific issue, government is running against itself. Because, for instance, one of the issues that people have paid attention to is the percentage of positions in government companies and government ministries that are held by Arab Israelis. So in a country where 20% of the population is Palestinian, how many Arabs work at the electricity company, how many Arabs are at the Ministry of the Interior, and so on. And the statistics are appalling, in a variety of degrees, from 0% to maybe 11% and so on, depending on exactly what you're looking at. And there is a government plan which set benchmarks to itself to change that, which is a wonderful thing. And they're not succeeding dealing with their own benchmarks. It's not enough, it's not fast enough, and so on. But still, it's a vector that is going in the right direction. And at the same time, there is an initiative to pass a law that would make it legal to give preferential hiring consideration for those that have served in the army at the very same positions. So one process and then the other process happening at the same time. The other comment I wanted to make in the context of what you were suggesting before, in the context of history, and here I'm not aiming to be a Zionist commentator, but I do want to mention, out of the very shallow historical knowledge that I have, that the whole notion of the State of Israel as a place that somehow exists under special circumstances, and thus perhaps it should be accepted domestically or internationally, that some things may be somehow different, that's a deeply anti-Zionist notion, because actually if one goes back to what Herzl was talking about and others and so on, then one of the key headlines of what Zionism, at least theoretically, was about, was creating a normal state. And that's an expression that kept repeating itself so many times, that it should be normalizing the Jewish situation in the world and having a normal state like any other state. So in that sense, leaders and politicians that self-identify today in Israel as Zionists, and on behalf of those values, are saying that these are special circumstances, and thus they justify discriminatory laws against Palestinians because of Zionism, they're at the same time working against the very core of the original frame of that ideology. But as you said, nothing is set in time, and things change.
Okay, we have time for one very brief last question, and then I'll invite Alex Raphael to make some concluding remarks.
Well, I've discussed this issue with Hagai the other day, but it does seem to me that the one issue that we have not really looked at here is the attempts by other organizations in Israel to try to bring about some form of equality rights for Arab Israelis. I think of Sakui particularly in terms of their organization to do it. And I think about it in the context of a movie I just saw, which my friend Alanisa Bomsoen did on education for Indigenous people. It's an incredibly moving and embarrassing aspect of Canadian reality to see, the kinds of denial of rights of children to go to proper schools. And I have to say that it's really been through the NDP that some step has been taken to do this. But I mean, these are, I bring it up as comparables and issues which I think in both societies there are groups grappling with these issues, which certainly in Canadian history go back long before 1867.
Unfortunately, we'll have to leave this as a comment simply because one of the realities of having a Morningside chat is that the day must now happen, and and there's also a cab waiting for Hagai outside. So before we leave each other, I'd like to invite Alex Raphael from the New Israel Fund of Canada to make some brief conclusory remarks, please. If you want to, the microphone, that's great.
Okay, I'm going to make these very, very brief. I would like to thank you very much for coming out to today's event. I am a graduate of Osgoode in 1979 and am a member of the programming committee at NIFC and a supporter of the recent efforts of the New Israel Fund of Canada to engage lawyers in a discussion of the issues which are so important to the work of the New Israel Fund of Canada. And it was terrific for Osgoode to team up with us today to make this event possible. So thank you to Professor Renaud, to the Nathanson Center at Osgoode, to our speakers, Hagai Elad, Craig Scott, and Cara Zwibel. And I think that the discussion today was really helpful. In a legal context, I think we saw an effort by all of the speakers to apply the principles of balancing. I think on the question of minority rights and the situation of Bedouins and First Nations people in Canada, the consensus was that things are wildly out of balance. And I detected a note of exasperation on the part of all of our speakers in those areas. On the question of the role of religion in the state, I think we heard a lot of very careful reasoning. I was very struck with Hagai Elad's image of this idea that you could place democracy and Judaism on some side of scale and they would reach some sort of perfect balance at some point. I appreciated Cara Zwibel's view that when we talk about the ability of the state to impinge on freedom, that the point at which that is justifiable is something higher than feeling uncomfortable. Again, Craig Scott made the point that when we're talking about the incursion of religious freedom, there is somewhere between the right of self-expression and the right to not have someone else's views imposed on your own, which has probably not been struck in the current proposal for a Charter of Values. So I thought these were all very, very thoughtful and helpful, and thank you again for coming out and joining us.
Thank you, Hagai. Thank you, Craig. Thank you, Cara.
Thank you.